Good evening to all IF members and MMA members. And as we really said, please put your mobile phone on mute so that it will not disturb the speaker. And as you all aware that Iif Chennai chapter conducts regular program along with MMA for our monthly event. And thanks for coming here. And we have today topic Data Privacy Act 2023, what it says, what it does not, by our speaker, Mr. V. Rajendran sir, Advocate, Chairman, Data Security Association of India. I think data security is all, we are aware of it, but I think as per my understanding, this act, what our personal data, how that can be utilized by others things, maybe the speaker can throw more light on this. To start the program formally, I request our chapter chairman, Mr. V.K. Raman, to welcome the gathering, please.
Good evening, IF members and fellow foundrymen. On behalf of Chennai chapter, I welcome you all for this wonderful evening program. We used to conduct management program every month in the last week of every month. So in that context, today also we are going to talk about the Data Privacy Act 2023, what it says and what it doesn't. So I welcome today's speaker, Mr. V. Rajendran, Advocate, Chairman, Digital Security Association of India, and also the IAF members and the MMA members. Please attend the program fully. You may raise the question at the end of the program so that the speaker will be in a position to give the answers. Thank you one and all. Welcome you once again. Thank you.
Thank you, sir. And now introduce the speaker. I would now request our IF SR Secretary, Mr. Palanimurugan sir, to come to the stage.
Good evening. I'm audible? Yes. Yeah. Good evening, friends. So it's my privilege to introduce today's speaker, Mr. V. Rajendran. He is an MABL MCOM with the CAIAB, a certified cyber forensic examiner from IDRPT, and he is a CISB from Indian Institute of Banking and Finance, and CASP from STQC, Government of India, a diploma holder in IT law, and a lead auditor in ISO 9001 and ISMS ISO 20001. He has worked for over 3 decades in the public sector IOB, Indian Overseas Bank, including 15 years in its IT department as a chief manager systems. He has handled areas like information system security, IS audit policy, CBS maintenance, ISO documentation, etc. After resigning from the bank in 2008, he has been practicing as an advocate, mainly handling cyber law cases, and as a consultant on IT security, technology in banking, ISMS and related areas. He has assisted various firms and corporate entities in drafting their IT security policy, ensuring compliance with ISO 27001 standards, and preparing for the eventual certification under the standards. He has also authored the book on IT security for bankers in 2012, then Prevention of Cyber Crime and Fraud Management in 2016, on behalf of Indian Institute of Banking and Finance, Mumbai. He has also published articles in various professional magazines and journals and appeared in print and electronic media on many occasions. He is a guest faculty and invited speaker on topics like cyber crimes, banking laws, and bank frauds in various industry bodies, universities and staff training colleges of police academy and banks. He is a past president of Cyber Society of India, and he is currently the chairman of Digital Security Association of India since 2018. I welcome Mr. V. Rajendran. The floor is yours.
Thank you, Mr. Sendil, the local chapter secretary, and thank you, Mr. Palanimurugan. Munana Thaiposam and Palanimurugan Arimugapaduthararu. I'm very happy about it. Happy to have been introduced by. Thank you, members of Indian Institute of Foundry. I mean, just roaming around. I have to be stationary standing at a place. It's okay. Okay, now gentlemen, we'll be... Okay, you can start. Okay. Well, friend, good evening. Thank you, Mr. Pradimurgan, for giving a very elaborate introduction. I never thought it would be so many lines of introduction. Just Rajendran, a good friend of Iif, would have been sufficient. Basically, I'm in Chennai, a proud resident of Chennai, Madras Karana, typically. Is my communication English okay for all of you? Pronunciation? Ella English, Tamil mixa? Okay, mixed. Okay. I would specifically like to know if anybody here is an, IT engineering graduate or a computer science graduate with, oh, very good, young man over there. Okay. IT and computer science, programming, that kind of thing. Huh?
Banking, sir. Banking IT.
Banking? Actually, working in a bank?
No. We provide ATM company, automated teller machine.
Very good. Very nice. Very nice. Okay. So somewhat relevant. Besides, anybody with a law qualification? Normally people say, no, one lawyer is an opinion, two lawyers is a debate, three is a pandemonium, and four is utter confusion. Only two lawyers is there, so we can... You are also...
I'm not a lawyer. I'm working with a cybersecurity consulting company, and I'm leading business for India, Middle East, and African market.
Very interesting. Very interesting.
Today only I spoke to you over phone. Mr. Vivekanandan, Assistant Commissioner of Police retired.
Ama.
Appa pesano sir calling. Okay. Membership form alla
Right, sir.
Oh, right. In morning phone panni. Correct. Sorry. Yeah, I remember that. Okay. In fact, I was in a bank for a long time. Now I happen to be a cyber law advocate, mainly handling these kinds of things. Initially, I was told to handle something on DPDP Act, a Digital Personal Data Protection Act. So DPDP, fancy name they have given. But then somebody here, I think you were chapter secretary, somebody said that is it going to be interesting, like will the topic be useful from an employment generation or a career building point of view of foundrymen? Foundrymen, career building and DPDP, I was not exactly able to relate. Anyway, I thought that I will be sharing some of the case studies on cybercrime in general. Would that be okay for you? Cybercrime, what a technology user. Nobody can say that I am not technology user. Inge yara na WhatsApp engita illa, I am not a user of technology yara irkingla. Minalla I used to ask how many are WhatsApp user nu kepen minalla 5 years back. Ipalla how many are not WhatsApp users kekra. In a group of 50, possibly 1 or 2 raise their hands. Yarume illa, I am not a WhatsApp user. Really? Everybody. Appa. WhatsApp user kadiyadu. Okay. How do you communicate? SMS, mail, something, or phone. Traditional, age-old phone. Very good. Wonderful. Nice to meet you, sir. Your name, sir? Rangaswamy. Acha. So as a user of technology, as a user of a banking application, my next question, of course, would be how many of you do internet banking, make payment by wallet and all that. I think most of you would be, Leah. I don't do internet banking, I don't have any internet banking, whether mobile or laptop, internet banking, I only do physical banking. Is there anybody like that? Nobody. Fantastic. Okay. Of course, payment by wallet banking, QR code is somebody may be hesitant. I don't normally make payment by mobile. Everybody is conversant with mobile bank. That makes my job much more easier, somewhat more complicated because I have to slightly scale up my presentation. All of you know it. So, in the present day context, in the present day technology penetration era, where exactly are we placed from a crime perspective, from a privacy perspective? Do you all believe that we have privacy now? Ladies still, normally young college girls, I can start with another example also. Okay, we can assume a young girl from a rural place like Tirunelveli, Thuthukudi comes to Chennai. She is going to join a company next day morning. Join his firm in an information system security firm, consultancy. That girl is joining next day morning. She is walking in Anna Sale. hurriedly some gentleman is taking her photograph while she is walking on the road. Okay? Do you understand the exact scenario? When somebody takes her photograph walking on the road in Anna Saleh, now she has, I would say, she has three options. One, she can shout at you. You don't have any right to take my photo when I am walking on the road. First option is to have an objection. Second is, she is too busy going to her office, another few seconds, she just not bothered, evan mele idicha, evan photo edutha anakanna, I have to rush. Enakku vela mukkiyam. This is the second option, neutral. Third option is, if she is, her ultimate aim is to be a celebrity in Chennai, become popular in TV or media, TV serial, anaka, she will stand a few seconds and give a foot pose. Okay, do you understand? She has all the three options. Okay. Which one of the options will you choose? If ladies are gents, which option will you choose when you are coming to Chennai for the first time? From a privacy perspective, which is closer to law, which is away from law now? What? First one, who said first one? Okay, first one, it is, so the other two are illegal.
Yeah, it's privacy. Why he has to take photograph? Without consent.
Very good, wonderful. But he says, it's a public place. I'm standing in the road. You are all in public. நான் சும்மா கேமரா திருப்பிட்டு இருக்கேன், எடுத்துட்டு இருக்கேன், அவ்வளவுதான். Then
he is not supposed to do that. In law there is no.
Where is it? No.
There is no freedom for him to take the photograph. Who has given the authority?
Okay, அப்பனா எல்லா பில்டிங்லயும் டிராஃபிக் சிக்னல்லையும் பார்க் ஹவுஸ்லயும் எல்லா சிசிடிவி கேமரா வச்சிருக்காங்க. அதுக்கெல்லாம்
let them take, sir. If he is covering me, I am objecting. Why he has to cover me?
He is not covering you. He is covering generally as a crowd. His camera is focused. You are coming there at that time.
He can take photo, but he cannot share it to others unless.
பாருங்க, இன்னொரு ஆங்கிள் வருது. அப்புறம் is there any other angle? சரி, he is taking a photo, he is keeping it in his mobile. திடீர்னு யூஸ் பண்ண போறாரு. அப்போ
It's an offense.
நான் மிஸ்யூஸ் பண்றாருன்னு சொல்லல, யூஸ் பண்றாருன்னு தான் சொன்னேன். I never use the word misuse or abuse.
You cannot use it.
It's neither misuse nor abuse. It is a use.
You cannot use it without the permission.
Very good, very nice. So, in the perspective, in a digital space, are we secure? Do you believe that we are all 100% safe and secure in a digital world?
Hardly. They are not safe.
Absolutely no.
Absolutely no. Very good.
Watched and monitored without our own knowledge.
Very good, wonderful. So you are a technical aware. I think session over almost. Now what are things to convey? This is exactly what I wanted to convey now. At the end of 1 hour, possibly 1.5 hours, we have cut it short to around 45-50 minutes only. I think by about 8:15 it should be over, sir. 8:15. Okay. So our secretary was telling you that don't interrupt him while he is talking. I don't believe it. You keep interrupting me. Keep on interrupting me. I like that. Otherwise, தூங்கிடுவோம், நானும் தூங்கிடுவேன், நீங்களும் தூங்கிடுவீங்க. அது வேண்டாம், ஓகேவா? அதனால் keep on interrupting me as and when. You don't need to wait till the end of the session to ask your questions. Okay? I know, sir, you said something.
I had a experience about 10 days back, sir. I was, in the middle of the night, I was discussing a very confidential information with my junior. About 10:30, around about the night. I can understand if the speaker is on, but my phone is on, but not actively working. It is on, like now, it is a silent mode.
Fine.
So I had a feeling somebody is reading my voice.
உங்க எவ்வளோ பேருக்கு அலெக்ஸா?
Then what happened, sir? What we discussed next day morning, I received an ad.
Quite possible. அதான் நான் சொல்கிறேன். Quite possible.
I started switching off my phone, but I'm making a.
Actually, frequently we used to conduct programs as part of Digital Security Association of India. January 6th, we had a one-day program. High Court Judge Jagdish Chandra was there. In fact, most of the High Court judges, they used to come as chief guest. இதற்கு 10-12 பேர் வந்திருக்காங்க. This time Jagdish Chandra came and DGP also came. Last time DGP Amrish Pujari came. This வேறு அப்பப்போ கூப்பிடுவோம் நாங்கள். அதில் we used to say very openly that the moment your mobile is on, be rest assured that there is somebody listening to it. Otherwise, நீங்கள் திடீர்னு Alexa, what is the weather in Chennai கேட்டிங்கனாக்கா, how is Alexa responding to you? You may be dull and sleeping mode. This Alexa or Siri iPhone Alexa எதுலையோ அதான் கூட she or he ன்னு தெரியாது, நான் வேகா சொல்கிறேன். never sleeps unless the cell itself is off. Cell on they are always awake. So there is every possibility that your conversation is not recorded but listened. So the moment you use a phone, particularly a smartphone, you are watched. இதுக்கு என்ன பண்ணணும், there are so many security mobile settings. நீங்கள் ஃப்ரீக்வெண்ட்டாக போய் ஒரு மொபைல் ஒரு ஆப்பை when you are downloading an app, it will ask you so many questions. But do we ever have time to read all those questions when you want app? என்ன பண்ணுறோம், கடைசியில் போய் I agree டக்குன்னு அடிக்கிறோம் இல்லையா? அந்த I agreeக்கு மேலே அதுக்கு அவன் தெரிஞ்சால் சின்ன பிரிண்டில் போடுவான் அதை. Actually, he prints everything in small print. He will ensure that you don't have the time or the eyesight or the keenness to read whatever he says. தெரிஞ்சுதான் போடுறான். Immediately we say, I agree, yes. So, அதில் all these things will be on. It will be permanent on. We have a right to access your data. We have a right to take your content. அது இதுன்னு எல்லாமே இருக்கும் அதில். இந்த ஆக்டில் நிறைய ஒரு ப்ரொவிஷன்ஸ் இருக்குது. இது மாதிரி ஒரு ஆப் வந்ததுனாக்கா, you have a right to take it up with the authorities. Now coming back to the example, even otherwise we do have the legal protection. We can tell the gentleman that you don't have a right to keep it. After the act is implementation ஆயிடுச்சு, but the authorities have not been notified still. Notification date தான் பாக்கி இருக்கு. When the notification everything comes, naturally you will have a better weapon in your arsenal. உங்கள் கையில் இன்னும் ஒரு பெரிய ஆயுதம் இருக்கும். You have a better arm with you, with which you can question the authorities, data fiduciary மாதிரி. For example, let me take another example. We are now around 30-35 people in this hall. Okay. At the time of entry, of course, you are all members here. If there are non-members, normally every conference we used to have a session at the entrance, like the registration process. தெரியல, registration process எல்லாம் invariably name, mobile number, address கேட்பாங்க. Sometimes எங்களை மாதிரி ஒரு ப்ரொஃபஷனல் சிமிலராக இருந்தால் வாட் இஸ் யுவர் இன்ட்ரெஸ்ட், வாட் இஸ் யுவர் குவாலிஃபிகேஷன் இன் லா, ஒரு 2-3 லைன் எக்ஸ்ட்ரா கேட்போம். With this we keep a database. Now one of the participants, he is interested in knowing the personal profile and address, mobile number of all the participants. He takes a copy of all these things. He makes a telephone call next day. Sir, நேற்று வந்துருந்தீங்க, அதே மாதிரி we are organizing another program, would you like to come and attend? We are organizing one more program. It is going to be free. We even offer lunch. எல்லாமே 1+1 ஆஃபர்லாம் இருக்குது. ஆடி தள்ளுபடி எல்லாமே, everything is there. Would you like to come? You will be shocked how this gentleman got my name or mobile number and all that. How will you know that the data has gone from here? My first question. And if you know that the data has gone from here, do you have a right to question this organizer? Sir, Sindhil, I am not blaming you. I am taking an example. Sindhil, I don't think he will do such things. But if any such thing is there, do we have a right to question the organizers for having shared my details? 100%. 100% what? You can question him. Only when you know that he has shared it.
Yes.
Will you be able to prove it? Quite I think. So, see, legally, this act, of course, throws the light on so many such things. In fact, I am not going to go by section and all that. It will be quite boring if I do it. I will just tell you broadly what is the basis of this act. What is the basis, why this act was actually conceptualized, what is the genesis of this act, gradually how it has taken a different avatar. What was originally planned was not this act. The basis of the act itself is Justice Puttaswamy case, or case, famous case. That case is a result of Aadhaar only. Aadhaar வந்து பழைய மன்மோகன் சிங் கவர்மெண்ட் வந்து, அப்புறம் என்டிஏ கவர்மெண்ட் வந்து, மோடி வாஸ் வெரி பர்டிகுலர் அபவுட் ஆதார். மன்மோகன் சிங் அண்ட் நந்தன் நீல்கனிலாம் தேவர் தி பர்சன் பிஹைண்ட் இட். மன்மோகன் சிங் வாஸ் தி பிரைம் மினிஸ்டர், நந்தன் நீல்கரி ஃப்ரம் Infosys, and about 2-3 top people from IIT, everybody was there. They made it as a concept. Subsequently, Aadhaar Act came. The Modi and this government was very particular in making it. Now they say they have covered 85-90-95% of the population. That's one thing. Now, Aadhaar itself is a privacy intrusion. Aadhaarல டேட்டா வாங்குறது தப்புன்ட்டு கேஸ் போட்டார் ஒருத்தர். The Justice Pottaswamy case is famous. Pottaswamy is not the name of the gentleman who gave the judgment. He is a complainant. Petitioner. Actually, it went up to Supreme Court. Supreme Court, a 9-judge bench. Fortunately, unanimous judgment. Privacy is a fundamental right. But Aadharla government benefit kaga vaangara ida inda data compulsory aakkodadu mathapadi Aadhar Act section 56 thara matha section of Aadhar is valid sonanga. All those things are secondary. Let's not go into the details of the case. One line in that case is still being spoken about till day, very particular. They said that privacy is a fundamental right. Adukku munnadi nobody even thought what could privacy be there. I mean, how to define privacy. In fact, after Jayalalitha died, all of you would have read many interesting cases in the paper. Nariya adikiti vandhudu. About Jayalalitha when she was there, so you are recording all these things. It's okay. What I am telling you is absolutely legal. Whatever has been published in the newspapers. So don't have to worry about it. I don't normally share any rumor in a public platform. So it was widely reported in the newspaper also that she had much diabetes there, and then the one finger in the leg was actually cut. So many things came, and then somebody filed a case stating that her body should be exhumed for medical examination. Because on the day when it was when the last rites were performed in the presence of top people, IAS, IPS officials, Sashikala and the entire ministry at that time, nobody had the guts to go near nobody was permitted to go near the body at that time. Nobody did. The learned judge said, even after the death, the privacy of a person exists. That is a very important sentence. That is quite relevant for me now. So your privacy does not die with your death. Even a dead man has a privacy. So unless the law or any other particular evidential circumstances exist, just like that we cannot say that privacy dies along with you. Privacy still continues, for a dead man. So these are all the implications or ramifications of privacy. What privacy means to you. What privacy means to him may not be privacy to me. To again come back to the example now. I was telling you about 3 options. Suppose you want to come to Chennai, become a celebrity, if somebody is taking your photo, you will not bother about privacy. You will enjoy that person taking your photo. You will not feel that my privacy is being affected. Right? Now, if Nayanthara or Trisha goes to the airport or goes to Central Station somewhere, there will be people flocking her to take a photo. Of course, they will object that you are infringing into my privacy. Tani our airport flight kuda yara mulla ipdi pandringa, all those things are there. But 25-30 years from now, if the same Trisha or Nayanthara goes somewhere when there is no market for her, if somebody takes a photo, she will not object, she will even welcome it. Because at that time there may not be people. Of course, there will be some hardcore fans of Trisha who would like her photos even 30 years from now. So, what is privacy today may not be privacy tomorrow. What is privacy for you may not be privacy for me. Okay. What is privacy at one particular point of time for one particular group of people in Chennai may not be privacy. If Rajini goes to some place in abroad or north, people may not flock him so much with video camera, audio camera and that. He'll just be walking comfortably in Himalayas now. So privacy itself is a relative concept. Privacy has not been defined. This section which said, the judgment which said that privacy is a fundamental right, they did not define privacy. Because privacy cannot be defined.
What is you mentioned about the person's entering the register and the whole coming subsequently? It may not be the fault of the organizer. I have seen persons attending the events, taking a snapshot of the attendees and then making use of it. If I apply the same logic to other what happens is the other so many personal information is there, but persons are able to hack and they are put in the website. So who is responsible for such a case?
Government, of course, is responsible.
And
There is no denying the fact that Aadhar UIDAI is the central government authority. They are responsible for any breach of your Aadhar data. They say that Aadhar data is 100% encrypted, cannot be hacked. But in this networked world, there is nothing like it cannot be hacked.
But what accountability they have?
What is the
Accountability.
accountability? Accountability, legally you can file a case that your privacy has been infringed. Then it will be difficult for you to prove that in a court of law. Then it again rests with the digital evidence. How exactly you know that the data went from here only? They may have to prove that they have taken all reasonable security practices and procedures. There's a particular phrase in the Act, earlier IT Act, Information Technology Act, Section 43A. If you have time, refer that. It uses 3 words: body corporate, personal sensitive information, reasonable security practices. So government can claim that I have put all the reasonable security practices and procedures in place. In spite of all these things, something has happened, some act of God or some unfortunate circumstances, something has happened. So government can reasonably protect.
Who will test the reasonableness?
Exactly. For that, IT Act 2011 again 2016 ISO 27001 certification and periodic audit of vulnerability assessment and penetration testing, VAPT. Some of you would have heard about the particular phrase there, VAPT testing, and then the software plug and which port, how the data gets stored, your TCP/IP, the packets transmission, all those things are there. Up to 90, 95, 99, 99.9%, you can say that we have taken all these precautions. At some point, there is some likelihood, some trace of likelihood that data can be hacked. Okay. So, what exactly is privacy? Nobody has defined it. It cannot be defined. What I am trying to tell you is that privacy cannot be defined, because privacy is a relative concept. Based on this only, so earlier IT Act was there. IT Act, Information Technology Act. When I say IT, I don't mean income tax in this forum. I mean Information Technology. Information Technology Act 2000, Information Technology Amendment Act 2008. Amendment Act 2008, it laid a lot of emphasis on, transmitting obnoxious or obscene, prurient to mind, அந்த மாதிரி phrase use பண்ணி ஒரு sexy obscene material இதில் போடும்போது what are the precautions that the government, what are the rights of the government to block those websites, அதெல்லாம் டீல் பண்ணாங்க அதில். அப்போ the privacy was being discussed. அதுக்கப்புறம் the government constituted a committee. I mean, those things are not included here specifically. It was first Meenakshi Lekhi committee. Meenakshi Lekhi was a very knowledgeable, tech-savvy MP. She has now become a union minister also now. 2015-16 Meenakshi Lekhi committee went into the privacy. Then Sri Krishna judge, he drafted a Data Privacy Act in India. அதெல்லாம் கொண்டு வந்தாங்க. அதுக்கப்புறம் the CII, FICCI and Data Security Council of India, there are so many industry bodies influenced by the MNCs. Influenced by MNCs like Google, Twitter, and of course Microsoft and many other corporates who felt that the moment such an act comes, our business would be impacted. So in fact, somehow there was a lobby working against privacy. Then subsequently, the previous NDA government, it went 2019, and again this government came. Fortunately, the same IT minister was அப்போ இருந்த ரவிசங்கர் பிரசாத் இப்போயுமே இருந்தார். இனிஷியலி இப்போ ஐடிக்கு அவர் கிடையாது. இருந்தபோது கூட அகைன் he said data privacy act will certainly come அப்படின்னாங்க. But again the powerful lobby, there are so many people working against data privacy. Why should we add something on privacyங்கிற மாதிரி, in spite of the fact that Supreme Court has said that privacy is a fundamental act. What are you going to do to prevent online fake news? Online fake news is the biggest menace. Online fake news, online obscene material, pornographic material online. இப்போ pornographic material டிவியில் வந்தாக்கா அட்லீஸ்ட் ஒரு டிவி ப்ராட்காஸ்டிங் ஒரு செல்ஃப் ரெகுலேட்டிங் பாடி இருக்குது. there's a self regulating body. Every TV is not subject to something like a film censorship board மாதிரி feature film censorship certificate கிடையாது டிவி சீரியலுக்கு. But they have self regulating body. But for an online news portal, today who is an online journalist, you tell me? Who is an online journalist? Everybody who has a smart phone in his hand is an அவ்வளோதான். யாருக்கெல்லாம் ஆன்லைன் ஸ்மார்ட் ஃபோன் இருந்தாலும் இஸ் an ஆன்லைன் ஜேர்னலிஸ்ட். வேணுன்ட்டு போன வருஷம் நியூஸை போட்டு இப்போ நடக்கிற மாதிரி போடுறது, எங்கேயோ நடக்கிறதுக்கு பேக் ட்ராப்பாக மாற்றி போட்டு இங்கே நடந்தது அம்ஜிக்கரையில், அது அம்ஜிக்கரையே இருக்காது, வேறு ஏதாவது ஊராக கூட இருக்கும் போட்டு. ஸோ திஸ் இஸ் வெரி பிக் மேனர். Supreme Court wanted to do something about it. They have been telling government. I mean, all those things are secondary. Now, what is the question of privacy? Subsequently, the P.P. Chowdhury committee came. They also came out with another version of the act. Suddenly, the minister said that I am not passing any act on privacy. I am only more concerned about your data protection. So, slightly privacy they deviated towards data protection because they could not define privacy, and particularly privacy by itself is a very interesting concept. I will tell you how is privacy in India vis-a-vis the privacy in the West. Actually, West last some 6-7 months back I read a case in California court நினைக்கிறேன் யூஎஸ்ல. என்னாச்சு, a husband filed a case for divorce stating the reason கேளுங்க, ரொம்ப ரொம்ப இன்ட்ரெஸ்டிங்காக இருக்கும். Giving the reason that my wife is looking at my call log every day. So she is infringing into my privacy. And the judge in the second hearing, he gave divorce also. No, call log in the mobile is a very, personal. India அது மாதிரி பண்ணால் நம்ம பாதி பேர் வந்து தனியாக தான் இருப்போம். If such a privacy definition comes to India, if such a judge or such a things comes, I shared this joke while addressing police and lawyers also. Lawyers are like, sir, நீங்கள் வேறு நாங்களாம் என்னைக்கோ போயிருப்போம் சார். Because the Indian definition of concept of privacy is not that. Still we believe in sharing our happiness and grievances. Of course, even divorce rate ಜಾಸ್ತಿ ಆಯಿತು. In fact, many social thinkers are quite concerned. The number of family court cases, you பார்த்துருப்பீங்க நினைக்கிறேன், data statistics says that in the past 10 years it has increased phenomenally. Chennai had only 2 family courts about till 10 years back. Now, Chennai level of 10 division, every division has around 2-3 family courts. There are about 20 to 25 full-time family court judges in Chennai. Every day. Chennai மட்டுமே. Chennai சிட்டியில் நான் சொல்கிறேன், சென்னை சிட்டியில். In தாம்பரம் இது ஆலந்தூரில் இருக்குது, சிட்டி சிவில் கோர்ட் இருக்குது, ஹைகோர்ட்டுக்குள்ளே தனி ஒரு காம்ப்ளெக்ஸ் இருக்குது. தெர் லாட் ஆஃப், ஏன்னா அந்த அளவுக்கு ஆமாம் கேஸ் இருக்குது. ஸோ நம்மளும் ஃபாஸ்ட்டாக வெஸ்டர்ன் நோக்கி போயின்னு இருக்கோம். வி ஆர் நம்ம இந்தியாவிலையும் பரப்ஸ் another few years from now இது மாதிரி கேஸ் வரலாம். இல்லை என் லாகை பார்த்தாரு இவர், எனக்கு பிடிக்கல அதெல்லாம் சொல்கிறது. ஸோ தி கான்செப்ட் ஆஃப் ப்ரைவசி இன் இந்தியா இஸ் என்டையர்லி டிஃப்ரெண்ட். இன்றைக்கும் என் வீட்டில் நான் பிஸியாக இருந்தால் ஒய்ஃப் ஃபோன் எடுப்பாங்க. இப்போ சாரு ஒய்ஃப் எடுப்ப பேசுவாங்கன்னு நினைக்கிறேன். உங்கள் ஃப்ரெண்டு மொக்க போட்டு வர அவர் தான் ஃபோன் பண்ணுறாரு, இல்லைன்னு சொல்லுவா, இல்லை பூஜை இருக்குன்னு சொல்லிட்டு பாரு அவர் அடுத்தது. இது மாதிரி திங்ஸ் ஆர் காமன் இன் இந்தியா, whereas in West it doesn't happen like that. So Western concept வேண்டாம். I mean, let us will be digressing it. Singapore Act இருக்குது, யூஎஸில் இருக்குது, every country has its own privacy act. On that basis only India wanted to have its own privacy act. But some of privacy அப்புறம் என்ன பண்ணிட்டாங்க, gradually it became like data protection. So data protection is the utmost important for the government, not the privacy. So privacy protection angle, I can bring whatever your privacy that I can take care, but basically your data will be protected. Now, data protection or a data sharing has a very interesting thing. There are 4 kinds of data, but 3 kinds I would say particularly. Something about you which everyone knows, which you are sharing very easily in your Facebook, LinkedIn, or friends are எல்லாத்தையும் சொல்கிறீங்க, married, you have children, or working in this place. I mean, all things are very common. Certain things known to everybody. Certain things known to your close friends and close family circle only. Second. Third is certain things known to nobody except you. உங்களுக்கு மட்டுமே தெரியும். Absolutely confidential. Nobody in the world knows about it. Only I know. I am keeping it highly confidential. I'll reveal it to the appropriate person at an appropriate time. Third facet. There is one 4th angle to it. Some data which you also do not know about you, but known to whom? Something about you which you also do not know about you, but it is known to whom? யாரு?
Google.
Fantastic. யார் சார் இது?
சார் நானே தான் சார்.
யார் சொல்லுது? நீங்கள் கூகுளை மட்டும் சொல்லலை, known to every company which has a
Transaction has taken.
which has a major presence in network, like Google or Microsoft or HP, whatever you can call it anyway. Yeah, networked sharing information. Something like a deep fake. Mostly deep fake. You do not know how you behave at a particular point of time. You do not know what is your favorite dress. You behave in such a thing. You move your hands and legs in a particular fashion. You would not have noticed. But an intelligent, what is normally called deep fake. Deep fake never the word is becoming very popular these days. My entry also came in News 18 last month. They were asking me about that who is that? Rashmika Mandanava. Rashmika some. Her picture was deep fake. Pond became very big issue. Then there was a debate. My entry also was telecasted. This is about 2 minutes. The presenter asked me how to put an end to it. I said no. We cannot put an end to it because technology is part of our life now. We can never end technology. We can keep on protecting ourselves. The more technology grows, our law should be strengthened enough, our jurisprudence should be strong enough, our legal fraternity should be careful and cautious, educated enough to nab the culprits. And in India, the biggest problem is it is the certainty of the law which is different, which is the deterrent, and not the severity of the law. I mean, I can put it the other way. It is the certainty of punishment. It is the certainty of punishment which is deterrent and not the severity or the multitude of laws. We can have severe laws, restrictive, multitude, lot of laws, but it is the certainty of punishment which is the deterrent. In the tappu panna ulla poiduvongara, that fear we have to inculcate. But in the present Indian judicial system, what happens is that case gets dragged on for a number of years. Typically, in some cases, where even a simple accident case gets dragged on for about 10 to 15 years. Ultimately, the person says that I was not driving at that time, or perhaps I did not have a driving license at that time, something. So, all those things can happen here. In this present circumstances, deep fake mari irkumbodhu, there are certain things which you do not know about you, but the technology knows. Now, this is the issue with the data protection authority or the data protection law has to aim. Will such data, which is not even known to you, can be protected? When you know that I have 1,000 rupees in my pocket, I can protect it. I don't know what is there in my pocket. I don't know whether it's my data, whether careful, whether it's sensitive data or not. But how do you expect the government to protect your data when you yourself are not aware of the data? Isn't it? So these are all the actual ramifications, implications or ramifications of the Data Protection Act. This is just about the objective, what the objective says. It is an attempt to bring a harmonious data privacy. Ultimately, now data privacy is not there. So frequently, I'll be using the word data here, data and information. The Act uses both the words alternatively only. Though technically data and information are slightly different. How is information different from data? Can anyone attempt defining both? What is data, what is information? Are both same or?
Data is a raw material, information is a process.
Very good, brilliant. Exact one word. The data is raw format. You said it. You said it. Okay. Your name, sir?
Fernando.
Okay. I request all of you to give a hand. Fernando. Very simple definition, data is the raw format. A processed data is information. Very simple. But as far as the privacy is concerned, privacy encompasses both. The privacy of data is as important as the privacy of information. Okay, very clear. So these are the stages. We collect the data, we process it, we storage, retrieval, erasure. The last word is very important. Last word is really quite interesting. You take a room, say in Uti, Kodaikanal, Trichy, Madurai or somewhere there. What the receptionist, they want some ID card. You give a copy of Aadhaar. there is a Xerox machine. Immediately he goes to that thing. He takes a copy. He makes the entry, gives it to you. You vacate the room in 24 hours or 2 days or 3 days. Your Xerox Aadhaar is still with him, no? For how many years, how many months, how many days? Have you ever thought of the possibility of his using it or misusing it or abusing it or whatever? That is where the data erasure assumes enormous importance. Do you take care to ensure that the data is erased in the sense from his system, or physically he is keeping it in a file? Now after you vacate, do you ask for the copy, you tear it and then put it in the dustbin?
Can we ask back that whatever you
As per this act, actually this act has a lot of provisions. You can ask him. You can certainly ask him.
But they were claiming that it's supposed to be.
Exactly. So it depends upon government rules for how many days you have to keep. This act also gives an example that in the case of a bank, 10 years after the bank account is closed, 10 years after the bank account closed, your bank account opening form and other details will be maintained with the bank. 10 years even after the closure of the bank. But we have a trust in the bank. See, Indian Overseas Bank, Indian Bank, Canara Bank. Bank officers may not be cheap enough to take out the other data and give it to everybody. Of course, every industry has some 0.5, 0.2, 1% of people who can indulge in fraudulent activities. I am not going into those things. Generally, there is a trust. But in small private entities, there are so many Xerox shopkeepers who were caught in such thing. This act was originally, this kind of criminal activity was originally called, so by about 8:24, 8:20, what time I should conclude, sir? You tell me the time. 8:50, 8:20. You say 8:15, okay. Even right now, you say 8:05, another 1 minute will do for me. In fact, I don't mind, basically. 8:20, fine, okay, fine. So, keeping someone's data and misusing it is something like scavenging. It's a kind of cyber crime which is called scavenging. What the scavenger does, she takes the paper there, she throws it. Suppose you write something there, throw it in the dustbin. At the time of throwing in the dustbin, the scavenger or the sweeper finds something interesting. She is taking it, she or he, whatever, keeping it, finds that is our username, pin mari irukkedhu, something like keeping it and then using it. Is it a crime now? But actually it has been thrown by you.
So you have only thrown it.
Is it a data theft? My question is it, okay, I can rephrase my question. Is it a data theft? Is it a crime? Two questions.
It's a data theft.
How many of you will agree that it's a data theft? Which is very smart. There is no data theft there because you only were throwing it there. For the dustbin it is taken. So at least the point it has been taken, it is being read, is not a crime. When does a crime start? Exactly, when misused. When there is a criminal intention. In legal circle, it's a very important phrase, mens rea. I do not know whether I am using that word somewhere in the slide. MENSREA. It's a Latin phrase, means criminal intent of mind. When your mind has a criminal intent, that is the trigger for the crime. So in every criminal activity, you have to prove that with a mens rea only he went there. With a mens rea only he did this.
So you mentioned about taking the data. When installing the apps, persons invariably are forced to give whether or not, knowing the impact of it. But how about cookies? Cookies take away the data without any asking for it.
Cookies is a okay, tell me, complete.
Cookies are just how it is built.
Cookies is a technological capability, technological enablement, not capability, technological enablement to access your browsing history basically. But some apps, especially internet banking apps of many banks, they will not work if the cookies are disabled. They say your cookies must be enabled only. But all those companies who use cookies, they are governed with this act now. So this act has a very good answer for your query now. This act has a query, this act has reply to such doubts. It says that as a data fiduciary, as a data principal, what are your duties and responsibilities when you handle public data? You are accountable. Now coming back to the example here, when 20 people come and register things here, the person who is taking the data is responsible for the upkeep. Think of it from another angle also. The hall has around 35 to 40 people now. Okay. Now, your secretary or chapter chairman has a habit of live streaming. Live streaming of the proceedings. But one gentleman here, he says, sir, I'll attend the event, but I don't want my picture to come as part of the live streaming, because I now told my wife that I'm going to Anna Nagar. I mean, something like that. Something like that. Or possibly my wife does not like IAF. She doesn't like me going to IAF. So in fact, I don't want to tell her. Huh? Correct. So, perhaps somebody says that I'll attend the seminar, but I don't want my photo to be, my picture to be shown in the YouTube. When you are showing his picture also as a group, you are, are you violating privacy? Violating his privacy. But it is part of your contract. When you come inside, you have to agree. You have to agree to come and sit inside the hall.
The program will be recorded.
Correct, in fact. So, before starting, I said that you need not tell me that I'm going to record my speech though, right? Okay. But he was smart enough to tell me. Had he not told me and recorded, I would have made it an issue of privacy. I would have made it the first lesson in the data privacy breach. So, you have to say very clearly, this is part of my bilateral agreement with all the participants. When you come here, there is a likelihood that your photo, your picture may be part of the video live streaming. Or, in those days, theatres, there used to be a separate no smoking zone. You go inside and smoke. If you don't want your photo to be shown on the YouTube live streaming, you go and sit in that hall, listen to it, so that the camera does not focus you. Something like that. Okay. So, these are all the actual ramifications of data privacy. These are all the 4 players, 4 parties. Very important words. Just spend a few seconds and try to understand the meaning of these words. 4 different set of people who are affected by the Data Privacy Act. I am consciously not going to the section by section debate definition and all that. I am making it very user friendly because I am aware that this is not a lawyer's forum. So, from a user perspective, user, data principal, concern manager, all the 3 form a group. Okay, now let me come to this example. About 30-35 people attending the program here. Who is the user, who is the data principal, who is the concern manager now? Tell me first, we are running short of time. Exactly. All the participants are users. All the participants are data principals. You are the data principal. The moment you enter your data, roll number, mobile number, so employee ID ka roll number. So, normally in organization we have that employee ID. No? Okay, employee ID or your, whatever is that. So, you own the data. You are the data owner, data principal. Or you tell your PA to fill up that form on your behalf. You are a very busy person, chairman, you tell you, PA form, about that PA is your consent manager. You understand the concept now? So, you are the data owner. Now, who is the data fiduciary? Second party. Who is the data fiduciary? SDF is the significant data fiduciary. Both are same. A data fiduciary in a large measure who handles more than 5 million records of 50 million data who is a significant and the framework, those rules are getting from now. But just suffice to remember that a person or a company or an entity who handles enormous amount of data is a significant data fiduciary. So, naturally, you will be a data fiduciary, not a significant data fiduciary, because you handle small data, about 100 and 120 members of IAF. Okay. So, you are a data fiduciary and you are also a data processor. What is the data process you do? You take all the data, you enter it in your Excel sheet or some part of the thing, then you have the follow-up. Last meeting you didn't attend, next meeting you will, normally we do it. So, you are a data fiduciary, data processor. Then you will have a data protection officer. Now, I come back to the question. I think somewhere there you are asking me. If you have a fear that data has gone out from this database only, you can question the DPO of this IAF, Data Protection Officer. When you collected the data from me, you were supposed to protect it. You did not protect it. From here only, the data has been breached. So you get the point? These three come as one. The next is Data Protection Board. When there is a complaint, to whom will you go and approach? It is something like RBI. When there is a dispute with regard to the bank database, you go to the Banking Ombudsman or Reserve Bank of India. When there is something on telecom, you go to the DROI, like that. It's a Data Protection Board. Data Protection Board will have 2 technical members, 2 lawyer members, 1 chairman. Nobody has been appointed, though the act has been passed on 10th August, I think. I think perhaps the government is taking its own time, thinking of under the dispute whether to involve 1 judge from Supreme Court or 2 judges from the Supreme Court. Judge should be part of the board. I mean, there's a lot of discussion going on there. The fourth is a lawmaker. The government.
Huh? Be, specific to a company or...
No. Data Protection Board is something like a Reserve Bank of India and TROI, exactly like RBI. Just like RBI has branches in about 17, 18 local chapters, DP, Data Protection Board also will have branches throughout India. What they envisage is a big setup with about hundreds of people there, with a board chairman, technical members, legal members, like those things. But the appointment has not come still. Yes, sir.
Yes, sir. And the scope will be within India or how do you...
India. Fantastic, very good question. Only in India. Only in India. Because,
the reason for asking this, I touched upon the cookies. Apps Indian government may control which app may or may not be used by Indians. Cookies, we browse websites across the world. They collect the data.
Exactly.
So our personal data goes out of India. So who controls that?
Those things, so long as the market is here, so long as the data principal user is here, this act will certainly bind that company which is doing business here. In fact, an interesting case here is that even much before passing of this act, 2021 August, I think, a case came up on how to regulate the MNCs operating in India. At that time, IT ministry, not the law ministry, IT ministry came out with the regulations stating that binding the MNCs operating in India. Because before that, if you have a problem with regard to Facebook or WhatsApp and anything, immediately Facebook or WhatsApp, including Google, they will say that we don't have a branch in India, right? Haven't you heard of that? Now, if you have a complaint against Canara Bank or IOB, Indian Bank or any other, Airtel or BSNL, immediately go to the nearest branch and at least see the person and shout. We have satisfied that. We can see somebody. But can you do such a thing to a person with whom you are sharing a lot of your data? Something like your Facebook or Twitter, somebody. Your Facebook or Twitter, whom will you approach? That's a very big question, and courts were finding it very difficult to tame them. At least one Delhi High Court judge, he said that we have to have a branch here, and then the significant data processes in India, they should have an office, they should have a 24/7 access, Gmail ID. All these rules were passed, and they were given 90 days time, 60 days time, I think. Then exactly on the last day, you know what? Twitter submitted a petition to Delhi High Court, said that we need more time. Just to tell the name of who is the Indian contact person, who is going to be our Indian CEO, what is the email ID of the Indian person. Because all these companies were comfortably taking shelter under the argument that we are not Indian companies, but we want Indian market. We want Indian market which is billions of dollars worth and billions of users worth, but we don't want Indian government or the Indian judiciary system or Indian court or lawyers to bind us. This was a very, I'd use a very simple word, very pathetic situation. I don't want to use any harsh word because I'm pretty aware that my words are getting recorded here. It was a very pathetic situation. So sometimes governments comes out with very strong enactments, very powerful. You have to give it. Ultimately, he gave the name. But unfortunately, the person whose name he gave to submitted, they resigned. They resigned, and then Twitter, Indian CEO changed it. All those things are secondary. But now at least we have a Facebook or a WhatsApp or a Twitter, anybody in India against whom you can file a case, who is responsible. So these are all the things there. Okay, yes sir. So data fiduciary, I told you, remember those 4 things. Straight I can go to the last slide now. This is what basically I wanted you to understand. But any data which is not computerized will be beyond the purview of this. It's a very simple thing. Digital data mattumna comes within the purview. If you take all these 20-30 people, you are filing it in a physical paper form, physical paperly you are taking a Xerox, it never goes to any computer, means this act will not apply at all. Even if you maintain around 100 to 150 people membership register, physically filing it. But in the present day world, such things may not be there. The moment there are about 40 people's data, we tend to put it in some Excel format, put it as some part of some computerized system, a digital format, so this act will come. Okay, so that is with regard to the act of applicability of the act. So personal, yeah.
Sorry, yeah.
It's okay, no sorry, tell me. We have about 3-4 minutes, 5 minutes more maximum.
Government of India data which are published in the interest of public interest, without the consent of government, without getting the approval, either through Tamil Nadu Department of Information and Public Relations, like TMDITR or anybody, under press media category, under digital electronic data
Yes.
broadcasting,
Tell me.
without the consent, even though it is written, issued in the interest of public interest, if you publish that will also be controlled and you come to the problem.
Exactly. In fact, this act very clearly says the data available, made available in public is not controlled, it says. Data which is out of the purview. Actually, if you are interested with what the law says in England, what the law says in India, it may be slightly beyond the purview of the discussion. In England, GDPR one irukku, General Data Protection Regulation, the entire European Union, all the countries are bound by it. There, what is publicly available also binds them. But Indian Act specifically has excluded data which is publicly available or made available in public. Actually, once I was addressing a lawyers forum, there one interesting query came, made available in a public made by whom? If the person himself has made it available, then okay, data doesn't by me. If it has been made available by a person mischievously, without the consent of the data owner, then his question will come. So this section is silent. I can take a shelter under the argument that it is already made publicly available. But you have to file a case against that gentleman who made it available. In that case, you may have to file a case against the government department which has made your data available without your consent. Got the point? Am I confusing you? Okay, very good. Confuse pannalana sandosham da.
Session they can ask individual questions.
Yare?
No, after your session people can ask individual questions.
Yes, of course. Yanakku onnume illa. Now, this is late. I don't take the right to. No, and I am profusely feeling sorry for it. Okay. So, these are all the lawful, what the definition and part of it. So, data fiduciary is a very important word. Data processor is a very important word. Data fiduciary, data processor, they are both same. Data processor works on the instruction of data fiduciary. I mean, to take this example, you are a data fiduciary. You collect the data of the people here. You give it to your system administrator or anybody else who is processing it on your behalf. You give the data to him. You tell him the data process panni. From away from Chennai, Chennai residents are. I mean, data who is not in Chennai, who is not away. I mean, how many food we have ordered. I mean, those things somebody is processing it. So processing is done on behalf of the data fiduciary. So they are both playing the role in a synchronized manner. So data fiduciary, data processor, same role. Significant data fiduciary, I told you, all the banks and the service providers and the YouTube providers and all those big corporate people will come under this. They are going to fix a benchmark level. People who are processing more than 5 million or 10 million data will come under significant data fiduciary. Why this classification? For significant data fiduciary, they are given and so why should the classification be there? Why should they classify it as a data fiduciary and a significant data fiduciary? What is the need? And it's a very simple common sense.
Volume. There's a volume.
Volume. And the volume, they have to be fixed some larger responsibility. You have 10 data, but you have to camera photo. Somebody comes and takes a photo of all the persons. You can say, data, you will also say, okay, somebody is there. But Airtel cannot say it. Or BSNL cannot say it. Or a bank like Canara Bank, State Bank cannot say. Data somebody has taken. Can they say it? No. They are significant data fiduciary. They must be given added amount of responsibility. So the Act says you should have your own in-house data protection officer, data protection board representative, your data processor kind terms of contract. You should report to data protection board. You should take an internal action. All those things are internally there. That's what the Act says. Okay, got the point very clear. So data principal has a role. The data principal role, somebody was asking about the data right to erase. Right to erase. When you give a data to a company, you have a right to say that my data, you have to keep it only this time. Beyond that, you should not keep it. You have a right to say it. It again depends upon the bilateral contract. Suppose the bank says that it is as per our internal book of instructions and work manual that account holder's data we will be keeping it 10 years after the closure of the account. It is as per the RBI instruction. Either you have to accept his terms of contract and give your application form, or he has to come to your team, you have to decline opening. That's all. So basically it's a bilateral contract only. Other than that, you have a right to erasure. With that in play, you have to say, beyond this period, I have a right. And you have a right to get it modified. After giving the data also, at any point of time, so long as your data is with the fiduciary, data processor, you can tell him the last month I gave the data, I want this thing to be changed. This basically because we all give your data to the bank. After 2 years, we say that our address is changed. Very simple common sense, right? After a couple of years, we can say the mobile number is changed, or a change of address, or a change of employment, something, change of salary, something. KYC, many columns in KYC get changed frequently. So we have a right for amendment. All these things are there in the Act. So the consent, how you consent? Consent manager, okay. Then data protection. Somebody was asking about this. Data protection board is going to be set up now. They are not decided who is going to be the, so long as I recollect having read the newspapers, I don't think it has come now. But there are a lot of debates about it. Very soon it will come anyway.
But in the absence of a board, who is taking care of the legal aspects or the protection?
If right now, right now, the Act has come. The Act has been notified by the President.
Is, as of now.
Exactly. True. Actually, we are we are now in a transitory stage. Maybe a few months. Few months.
Is looking for some
yes.
period after the election, before the election.
Correct. But now one thing is very clear. When the Act comes, the data fiduciary should take a consent from all the account holders. That is, to face the situation that when the data protection board, everybody is appointed, at that time, every bank will give a mail to every account holder that your data is subject to the rules and regulations as per this Act. Every account holder has to give his consent at that time. I think there are a lot of procedures also there. You can send an email, you can send a registered letter, and the email is not responded within a reasonable doubt. You can presume that he is accepted. Or the last email, wherever he has responded, there will be the official email. There are so many things inside there. But basically, just remember that every data fiduciary should take a reasonable steps to contact you and take your consent. This is what the Act says. Clear?
So this Act doesn't give the consent.
Huh?
Suppose one doesn't give the consent.
Exactly.
To the primary state.
Yes. Close the account. Close the account. Close the account. In fact, the same thing is in the case of many apps. The earlier Data Protection Act, Data Privacy Act, which has been discussed. Then there was a particular section, I remember, just about 2 minutes. Section 18 or something was there at that time. They said that for app there are about 15 to 20 conditions. Suppose you are not agreeing with one particular condition in that app, you should be given an option to I agree without that. This kind of an app only should be permitted in India. But this Act is not so clear about it. But this Act anyway has a stipulation very clearly that when you are downloading an app, if you doubt that this kind of data is not necessary for this app. For example, you are going to buy, something like very harmless example, some book or some movie review, something like that. That app says that I can switch on your camera or I can access your contact. You feel that my contact, camera, audio, somebody was telling that my audio is always on. It's not necessary for this app. You have to immediately bring it to the knowledge and data protection board. He will bring down that app. He can question that why you are insisting on this condition. Actually, the Act also says that you should be given an option to not to tick only the other things. And that I doubt whether all the app providers will be so liberal, so compliant with the Act. Our Indian app providers or software industry is not known for its so much of compliance, not complaint, compliance. So, perhaps when you take it up with the data protection board, they will be able to take the, stick and show the power. Okay. So, this is a very important enactment from that angle, from a cybercrime prevention, from a data protection and privacy perspective. It is quite simple, quite easy. There are so many things like as may be prescribed, many things in about 26 times it comes. So many things are yet to be prescribed. What I am trying to tell you is that, as somebody was telling here, so we are now in the transition stage. Perhaps under 1 or 2 months, I think the things will get cleared by that time. Until such time, just remember these three are the major stakeholders in the data protection: the business, corporate and industry, the users, public. Until such time, government or we have to grapple with the situation of the owner. The another interesting thing is that the problem the government is facing with regard to big corporates, including particularly WhatsApp, I would say that whenever government wants some WhatsApp or any such data to be shared with the government or part of any investigation, immediately WhatsApp says our data is end-to-end encrypted. Very favorite phrase. WhatsApp uses this phrase in everything, end-to-end encrypted. So even I will not be able to read the data. When my one user sends a message from Chennai to Kanyakumari or Mumbai or Baroda, whatever, even WhatsApp, I also will not be able to read the data. Though technically, I am not going to the technological capability of capacity to read or decrypt and all those things. It says that, okay? It says that. So, exactly. Yes, that's what I am telling you. So, you have a duty to divulge when the government questions you that your data is very particularly important for us to nab a terrorist or as part of a crime against the sovereignty of the nation or crime against the country and all that. And again, crime against the sovereignty of the nation, terrorist, it indirectly it will come to the media, will become a hyper mode, say that no, it's a curbing of the media's right to express. Our right to express is there.
It also opened the door.
Fundamental right. It opened the door for the government.
Misusing.
Government to misuse. Correct. It opened the door. Absolute misuse. Yes. It happened. There is a very good accusation, very good point in that accusation. The government is certainly going to misuse it.
But we are the present regime. People say,
I'm not going into the present regime or past regime. I'm not going to whether it is whether it's Israel-driven Pegasus or any other kind of thing and all. I'm not going to it. But there is a room in this accusation. Okay. So, owner has a right to protect. And government also has the right to protect. But government also has the right to protect the other's sovereignty vis-a-vis your data.
Owner's right to protection, not to protect.
Oh, okay. True. Wait, that's what I'm trying to know. That's what. Okay, that's what I'm trying to know. Actually, when the government says that it is my duty to protect the sovereignty or the data of 1,000 people, that your data has to be breached. I want to read your data. Only then I'll be able to protect the life or security of the data of other 1,000 people. Then what is the role now? So it's always a balancing act, right? It's a balancing act. So until such time we can think of something like 5 blind people looking at an elephant, like somebody says it's a good step in e-governance. You can look at the slide here. Somebody says it's too late and too less because this act should have come about a long time back. It has come too late and only too less. Even now it is, some people say it's going to be a toothless act. Some people say
it should have come in 2019.
Exactly.
Brought some amendments.
At least I personally believe that it should have come 6 years back. In the moment the Puttaswamy judgment came that privacy is a fundamental right, immediately government should have acted like at least trying to put in place reasonable steps on privacy. What is privacy? what privacy I should protect. To protect privacy, what are the steps I should take? These are the three things, you know. First is say what is privacy. To protect privacy, what I should take. What are the impediments I have now? These are the things. As a first step in that, it has come. So much scope for interpretation. Okay, with this, thank you. Thanks for the time.
Privacy is still an open issue.
Privacy is open. That's what I told you. Privacy is not defined. It cannot be defined also. As I told you, privacy differs from place to place, person to person. In fact, the word privacy does not come here, very interestingly. It's a data protection act, not a data privacy act. That's what I told you. It's a Digital Personal Data Protection Act, DPDP Act, not a data privacy act.
Thank you, sir. I think a lot of questions have come. If you have any questions, then I think we can have it during dinner time. When we come to the end of the seminar, to felicitate the dynamic speaker of the day, Mr. Rajendran, now I request our chapter chairman, Mr. Raman, to relate with Angavastra. Sir, I'm going to go. So now I request our past chairman, Iif Chennai chapter, Mr. Rajan sir, to facilitate the speaker with the momentum. Yes, sir. Okay, I think that's what I also read. Swararan sir spelled out. It's really eye-opener. Yeah, the many points which are not known to us. A lot of points I'm sure everyone has noted down. Yeah, it's a lot of takeaways, a lot of eye-openers because it's not known to us. Huh? Oh, you have to check because he is very particular. Let's see. Sir. Okay. Okay. Okay, I would like to thank the speaker who has taken a pain to come here and then present it, and unfortunately we could not pick him up. He has come on the way. I think he struggled a lot in the traffic, that's why there is a delay. We apologize for the same, and we also thank all the participants who come all the way in Persical and attend the program. And as usual, Chennai chapter conducts a lot of technical and management programs. We request you to attend. We will give you information on time to time. And thank you once again, and looking forward to meet you for our next program.